Hello, I'm John Fuller. We are continuing our discussion of the U.S. criminal court system, specifically our book, American Criminal Courts, Legal Process and Social Context. Today we are talking about the criminal trial process. This is, again, an important part of the court and probably the most visible part of what courts do, the criminal trial. It is during the trial that guilt or innocence is decided, and at the end of the trial, the judge will also make a determination as to the disposition of the case, whether the defendant, if found guilty, will go to prison or will be placed on probation or some other type of diversion program. Of course, in a trial, we all realize the judge holds a pivotal role. The judge has a number of duties that she or he must address when conducting a trial. Last chapter, we talked about the pre-trial process and the duties that the judge has in determining the admissibility of evidence. The judge must also enforce procedural law during the trial, where she or he tells the defense attorney and the prosecutor exactly what kinds of statements they can make and what types of evidence they can produce. The intent here is to make sure that the trial is conducted in a fair and impartial manner. The judge also instructs the jury, telling them what evidence to take into account, how to evaluate the law, how to match the law up with a particular case. The judge also has to maintain the decorum in the courtroom. He or she must ensure that it is done in a dignified manner and that people can conduct themselves accordingly and in a serious way. And finally, of course, there is a sentencing there where the judge will determine the sentence. Now, in determining the sentence, it gets interesting because it depends upon what kind of sentencing rationale the judge has. The criminal justice system has several goals, and depending upon which one or which of a couple of these goals the judge subscribes to, it can have a very big impact upon the sentence. For instance, one of the goals of the criminal justice system is deterrence. The idea that if I violate the law and I get caught and people see what happens to me, they don't go out and commit crimes themselves. This is really the basis of the whole criminal justice system. Think how chaotic things would be if everybody had to commit a crime and be punished before they decided committing crimes is not a good idea. Another sentencing rationale that the judge may have is retribution. Some people commit very serious crimes, and society demands that they pay for their sins, that the punishment fit the crime, and that for serious crimes, people get serious sentences because they deserve the serious sentences. Another sentencing rationale is incapacitation. Here the idea is we want to take people who commit serious crimes and isolate them from the rest of us. We put them in a prison behind bars and walls, and we incapacitate them from committing other crimes in free society. In some countries, in the Middle East, for example, they use incapacitation by cutting off the hand of a thief. And you cannot pick pockets so well if you don't have a hand. And so that's one way of making sure that people are incapacitated. And then a final sentencing philosophy that judges may invoke is rehabilitation, where they try to restore people to good behavior. And typically this is done through some type of treatment program, specifically drug treatment, family counseling for domestic abuse cases, treatment programs dealing with DUIs. So there's a whole range of treatment programs depending upon the underlying issues that were inherent in why the people committed their crimes. The judge has discretion in deciding what the sentence will be. There have been some movements to try to limit this discretion, and these movements have to do with things like mandatory sentencing, where the legislature will say, for certain crimes, this is the sentence no matter what, and the judge doesn't have that discretion. And we see this especially in some of the 3 strikes and you're out rules that courts have, where on the 3rd felony, people can go to prison for life, no matter how serious that 3rd felony was, because we've determined that they are a career criminal. This limits the discretion of the judge and shifts it to the legislature. And this is very controversial. Who should have the discretion? The legislature, who makes the laws for everybody, or the judge who is applying the law to a specific case? So in terms of the whole criminal trial process, there are a number of issues that influence and impact upon how that criminal justice trial process is carried out. Thank you.